Welcome to the Sanskrit Podcast, where the ideas of ancient India meet the modern world. Our guest today is Vikram Phadke. He's a practicing attorney who specializes in constitutional law, civil law, and service law. He has practiced since 2003. Today, Vikram is here to talk about the legal aspects of ancient Indian culture. Namaste, Vikram.
No.
Thank you for coming. So, Vikram, I want to start by asking you, is there anything unique about the legality of ancient India that we should talk about? Maybe we begin there.
Ancient Indian legal system, there is one very striking uniqueness in the system, that the laws do not emanate from the God or the prophet. The laws, the rules, the regulations are the conscious creations of philosophers, seers, and the thinkers. And one another very important aspect of our ancient Indian legal system is that the king was not the lawgiver, and the king, the Raja, was subordinate to the law. Unlike in the West or in other systems, the king was the fountainhead of law. He could mold, deviate, do as he pleased, and he was not bound by law.
Interesting. So, I want to probe a little further, because my understanding of modern Western law is that the church and the state are separate, but you are talking of before that, 10 commandments and things like that, before.
See, the terminologies of church, the state, secular, sacred, these are the terms with which to analyze the Indian system, it is grossly insufficient. We may not get the whole picture if we start analyzing the Indian system through these glasses. The system was entirely different, a product of its time and also of the geography. Comparison can be done only on peripheral things, looking at through these prisms. But however, the system as such was quite different, unique, as well as very interesting.
You just mentioned it's a product of its time and its geography. So, for a layperson, we hear only about Arthashastra and Chanakya. So, can you just describe what was the milieu, what was it like then, were there other big personalities, and how did that play out in society?
Before going to the personalities as such, if we see what were the sources of Indian law, ancient Indian law, and then we can go to the personalities as well. The primary sources in India, we trace everything to the Vedas. Vedas give a broad outlook, picture of the life and the values, but they as such do not prescribe or proscribe anything. They speak about truth, they speak about having a good life, they speak about having a noble life, but the prescriptions can be seen from the Dharma Sutras, from the Smritis, from the general practice, usage, and the rules and regulations within the small communities that existed then. In these, the foremost earlier texts, as we can say, were the Dharma Sutras. There is a literature called Sutra literature, which includes Shrauta Sutras, Grihya Sutras, and the Dharma Sutras.
So, Shrauta Grihya means what?
Shrauta Sutras are sutras or rules, regulations with regard to the rituals, yajna, yaga. And Grihya Sutras are with regard to the within the family, the conduct, all these sutras, how a householder has to live, behave, and more on the family picture. And these Dharma Sutras concentrate on the relationship between human beings, between the king and the subjects, and the contracts and the punishments, violence, crimes. These are the thing. And the next literature is the Smritis, which are like the codified law of ancient India. In the sutras, Dharma Sutras, we have Baudhayana, Apastambha, Vasishtha, Vishnu. All these were great personalities on whom the sutras, or who have given these sutras. The Smritis are also based on these sutras. Sutras are also broad frameworks, and the Smritis are the codified law. Here, Parashara, Yajnavalkya, Manu, all these are the luminaries who gave the codified law. And one another important aspect is the law which governed people was not static. It changed according to the times, it changed according to the places, and it also changed according to the circumstances.
But who was the judge who decided that this is an exception and we should change the law to suit this?
Yes. All these, Parashara is regarded as the oldest. Parashara Smriti is regarded as the oldest. And by far the most influencing was the Manusmriti.
So Vikram, just one doubt. I think it's really profound what you said, that the laws were written by philosophers and even the king was not above the law. I don't know if there are stories where the king tried to influence Parashara to bend the law for him, or it was just a given that the king too will be subordinate to the law. Because I mean, in the Mughal era, you can hear people were thrown in dungeons because they didn't listen to the king, the ministers and all. But in ancient India, it was not like that, in your opinion.
See, the ideal was that the king is subject to the law.
Correct.
And we hear no great instances where the king himself influenced for a change of law or sought for an exception for himself or for his selfish needs.
Yes.
No doubt there were kings, and it's human conduct that people would have tried.
The bad kings.
Whatever, not so benevolent kings.
Yes.
Who would have tried to get their ends met.
Yes.
But however, the accepted, acknowledged and well practiced usage was that the king is subordinate to law, and there is no exception. At least the commentaries, the law does not make any exception.
Is that, as a lawyer, I see that as profound. Is that a big deal, the way that it is? I mean,
yes, it is really a big deal. We experience it even today. Suppose it was at the whims and fancies of the administrator and not of the law. We would be at the mercy of individual whims and fancies. We are living as a society in a conducive and good atmosphere because it is not the rule of a man, but it is the rule of law. Even the Western concepts of rule of law, it is not the rule of man, but it is the rule of law. Every man, every king, every administrator is bound by law, and nobody is above law.
We were discussing earlier about this King Manunidhi Cholan, who we studied in history books in Tamil Nadu. Because a cow rang the bell, the king's son had driven his chariot and killed the calf, and when the cow rang the bell, the king told the charioteer to run the chariot over his son, thus equalizing the pain felt by the cow mother. And you had mentioned something which I didn't know.
This is a very interesting anecdote. Here also it shows that law is supreme and not, see, the prince, the king's own son, committed a crime,
Yes.
and that too against an animal. And the king was so just that he did not spare even his son, even when the cow rang the bell. And very interestingly, this sculpture statue is there even today for all of us to see in the Madras High Court.
I didn't know that.
Yes, and anybody who visits Madras, if they have time, they should visit the High Court there. And in the front, there is this statue, which shows that law is mightier than the king.
So you had mentioned earlier about the judge, the law changed, it wasn't static.
Yes.
So how were disputes resolved? Because I can imagine farmers coming and saying, my circumstance is different, why don't you change the law to suit this? So how were disputes resolved if this law was not static?
Yes, it is like this. As I said, there are various sources of law.
Yeah.
There are sutras, the smritis, but another very important aspect is also the usage and customs of those communities. And there were courts, and even the king was also the ultimate judge. But however, in a real practical sense, the communities, the guilds, that is the guilds of agriculturists, the guilds of artisans, the guilds of
Silversmiths,
merchants, the guilds of those
Jewelers.
professions,
Yes.
they used to decide the dispute. As in today's aspect, what we see as arbitration, wherein a subject expert is also made as a judge to decide the matter, because he will have expertise in those subjects and the conducts of people in those aspects, in those disputes. Even in earlier times, these disputes were decided not just on the written law, but also on the usage and also by the communities and the guilds.
Very
Hence,
interesting.
the justice was not only fast but also practical, and also the people who underwent them felt that justice was done.
Correct. I was just imagining a scenario where a goldsmith makes a mistake and his master says, I'm going to remove it from your salary every month, but this man is poor and cannot afford. I imagine that some arbitrator from that community would make some adjustment.
Yes, he would be in a better position. He is more suited than a third party judge who is not well aware of the happenings of that trade.
Yes. The manga has become a lotus, and why not use it as a jewelry? Why are you forcing this young man? So
mistakes do happen.
Yes.
Of course. But only persons who are proficient in that trade, in that field, would be in a better position to judge.
Correct.
Either it should not be very lenient or too harsh.
Yes.
It should be commensurate to the dispute in question.
So again, in all these movies, we see people sitting under a banyan tree and the gathering, and then the panchayat gives the judgment. Was it like that, except in a court? I mean, how would you describe the court appearance in those days, or imagine it? If you could imagine it, how would it be?
The first mechanism of resolving the dispute was within the family or the clan.
Yes.
Then came the involvement of the communities, the village communities. There the village elders would sit, discuss, hear both the parties and then give their ruling.
And it had to be followed, no exceptions.
Generally it was followed, but whoever was not satisfied, of course he could go to the legal mechanism established by the state.
So there was an appeals process.
There was a process. There was a process, but generally by and large what we have read and understood is that petty and small issues used to get resolved within the family or the community or in the village panchayat. And the present day panchayats though we have retained only the names, had to be modeled on the earlier this one. That was the thought
Correct.
process, of
Correct.
course, but now we are in a more centralized system.
Correct. Yeah, that makes sense. So, as a woman, I always assume that the legal system of ancient India was very patriarchal. All the names you said in the Apastamba, all of them are men. So, how did women fare in all this? I mean, were they viewed as without rights and responsibilities, or was it equality? Or equality itself, is it a modern idea of today's age and did not apply to that age? How did women fare in ancient India?
With regard to the luminaries, there was a very great luminary called Lakshmi Devi also.
Oh, I didn't know that.
Yes, and she has written a wonderful commentary on Manusmriti. It was not that there was dearth of women. However, to think that it was only patriarchal, again I wouldn't like to use this term because these terms are alien to our system. As I said, it would be very narrow. This is a small prism to look at our systems. Rather, I would say that it was neither patriarchal nor matriarchal. It was family oriented, and each one had his own place or her own place.
So even men were constrained, so if you look at it like that, even women had certain roles and responsibilities, and men too had these.
Of course,
as many.
Of course, there is no doubt. The laws, the system was centered around family, not on the father or exclusively on the mother. The division of property, succession was generally on the male line, because a system had developed that a woman goes in marriage to another family. She belongs to that family, not just to the husband. But one very important aspect is, from time immemorial, there is a concept of Stridhana in our legal system, that is the exclusive property of a woman.
Okay.
Yes, which could not be touched by anybody, not even by her husband, her children, her parents, anybody.
I didn't know that.
She could hold property exclusively, and in contradistinction, a man could hold property only as a family and not as an individual generally.
Oh, that's good.
Yes, no doubt a person could make his own money, but it was generally treated the money made by a man is for the family and from the family only.
Yes.
That is why we have the concept of Hindu joint family.
Yes.
But Stridhana was the exclusive property of the woman.
Okay, very interesting.
Yes.
And I wanted to ask you about divorce in ancient India. Did such a thing exist or not?
Human beings have always been the same, whatever the times and the places.
Yes.
They are instigated by the same instincts. And for two persons to live together, as it is difficult or good today, it was the same earlier as well.
Yes.
There was divorce, but generally it was not favored, even as of now.
Yes, agreed.
Society doesn't like for the families to break up.
Correct. And it's not good for children, you could argue all that.
Yes. The same thinking was also there.
Yeah.
And here also, there is one very important aspect I would want to say, that the grounds for divorce for a husband was very, very limited. Yes. Only he could divorce a wife if there was fraud played upon him during the time of marriage, or if there was continuous or habitual infidelity, not just one instance or so, habitual. This is a very important word. But he could not forsake his wife in all other circumstances. it was his duty to maintain her. He could take a second wife, but he could not abandon his first wife. And we cannot look at those times from the glasses of the present.
Correct.
But women had greater liberty of divorce. They had opportunities, not just opportunities, in law. They were entitled to get out of the marriage.
Yes.
If the husband deserted her.
Yeah.
And if he was removed from the community.
Yes.
For his bad behavior or for whatever reason.
Yes.
And if what you say that the husband, the whereabouts of the husband was not known.
Correct. Like
and
the stories of the ship he goes
and
away.
if the husband died, of course she could remarry.
Yes.
There was provision.
Yes.
In law as well. Though in practice it was very prevalent.
Was not very prevalent.
It was prevalent.
Okay.
In the ancient times.
Yeah.
We are seeing only from the time between the 9th and 10th centuries till the recent 1920 centuries, wherein our society was under continuous attack from barbaric hordes from outside the country.
That's how Sati and all started, I guess.
That's how people were forced. The whole Indian system was forced to become more and more closed.
Yes. Correct.
But when we regard as the ancient system, it was more open, more liberal and more natural. I would like to add one more thing, that the Smritis, the ancient laws provided that when a girl is taken away by force against her will, that is, it also includes rape, she could return, she could marry, and the forceful abduction or rape was treated as wrong, and she was regarded as chaste and a maiden who can marry, not remarry, but marry of her with her own will and choice. Yes, this is very interesting, wherein by legal fiction it was treated that she is a maiden and she can marry a person of her choice.
Vikram, you have given us a fascinating glimpse of how laws of ancient India are still trickled down to today, and also how they were different and what we can learn from them. I think it's been a wonderful podcast. Thank you so much.